I'm Mara Verheyden-Hilliard. I'm a constitutional rights, civil rights attorney with the Partnership for Civil Justice Fund.
Mm-hmm. And what work has your organization done in the district that may relate to the inauguration protests?
We litigate constitutional rights, free speech, First Amendment cases, particularly in the intersection of Fourth Amendment rights, so police misconduct in the context of mass assembly. And our cases have included major cases in the District of Columbia and cases around the country. But most significantly and most on point with what's been happening here in the district with the prosecution of demonstrators who were marching at the Trump inauguration are the cases that we brought, a series of cases that we brought over the last 17 years or so, starting with the April 2000 mass arrest in Washington, D.C. of more than 700 people. And these were demonstrators who were marching against the IMF and World Bank. It was an anti-globalization protest. And the demonstrators were trapped and detained in a mass arrest without probable cause. They were taken in and hogtied wrist to ankle, some for 24 hours or more. And within 2 years of that, there was a second major mass arrest that was similar of 400 people in Pershing Park. And in that case, those 400 people again were trapped, detained, arrested, and hogtied in stress and duress for more than 24 hours.
And actually the U.S. Attorney's Office tried to justify hogtying protesters in that situation by saying that they were preventing mass fornication.
Well, in the context of our litigation, we deposed the chief of police, the commanders, pretty much everyone in command in the District of Columbia. And in one of the depositions, when we were demanding to know the basis for hogtying, in fact, they told us that they were hogtying demonstrators to prevent the demonstrators from fornicating. Because, of course, when people have been falsely arrested and held on buses and thrown in jail, like that's the main thing they're thinking about at that moment is, you know, hanging out with everyone else in jail.
Mm. And what were you able to achieve through your litigation?
Over these cases, the two class actions and several other cases, there were a number of major developments and things that we uncovered in the course of litigation that really showed what the District of Columbia was doing, that it wasn't just sort of an abstract violation of First Amendment rights, that these were intentional tactics that were designed to deprive people of their ability to assemble, to speak out. And it was really a playbook that we saw in Washington, we saw used in other places and other mass assemblies around the country. And the way that we look at litigation when we litigate it is to really look at what is it that the police are doing, what are the specific tactics they use, and how do we disarm them of those illegal tactics. So in the course of the litigation, there were a lot of reforms that we demanded because the critical point of litigation is to have institutional change. And in 2005, the District of Columbia enacted into law what was called the First Amendment Rights and Police Standards Act. It came after a series of hearings that the District of Columbia Council held focused on the cases that we were bringing. And they asked in those hearings about reform that would address the issues that we were litigating because the District of Columbia attorneys were engaged in scorched earth litigation. But the council and the people of the district really want to see some change, and they were going to wait for the district attorneys to do nothing and just drag these cases out. So while we litigated and continued litigating for years in these cases, we also worked another track. That track caused this change, this First Amendment Rights and Police Standards Act. And what that act entails are not just policies, but law that binds the police in the District of Columbia. It's those laws that are on the books that the District of Columbia Police violated on January 20th, 2017. Those laws, had they been followed, as the police are obligated to follow them, would have ensured that this dragnet mass arrest never occurred. It stops the police from doing exactly what they did here, which is to engage in mass arrest devoid of probable cause. It requires the police, when you have a mass demonstration, even where there are acts of damage to property, that they have to act with precision and that they can't act against a group as a group. And the reason for that is when you're dealing with the First Amendment, the Supreme Court has recognized that it's critically important that you have a precise response, that if there's someone that breaks the law, you can't, guilt by association, arrest everyone else because they share a political view. But that's what the U.S. Attorney's Office is doing here. They're really punishing people because they're in proximity. They're punishing people because they shared a political view, not because they engaged in a criminal act.
Mm-hmm. Yeah, and we see that today in the trials when the prosecution, the government, makes the argument that protesters who were wearing black were abetting the crowd because abetting the rioters because they were being reabsorbed and totally ignoring the idea that people may wear black to indicate their political ideology and whatnot. So you wrote these laws for the DC Police Department. What they're saying now in the trials is that these laws don't apply because the group was not a First Amendment group, it was a riotous group. Does the language of your laws allow for such a thing?
That's a false statement. The laws explicitly apply in circumstances where there is, in fact, criminal act. That's the point of the law. The point of the law was to say that if you had a group of people and the people were engaged in First Amendment activity, which means chanting, marching, all of those things that we would recognize, if some people in the group engage in a criminal act, then the police have to act, and can act, obviously, against people that engage in a criminal act. But they can't act against everybody else simply because they're in proximity. And the law requires that there be dispersal orders, that there be notification to people. There are additional requirements that they log actions they take in terms of dispersal orders and orders to act against a group as a group. And in fact, the law is very specific that as a first step, you shouldn't even be able to disperse and extinguish a First Amendment assembly. I mean, that's even down the road. But the police here are acting in derogation in total of those laws. And we believe that the reason they're doing that is because, among other reasons, is that the chief of police now is Peter Newsham. And he was interim chief of police at the time. This was the first mass demonstration under his leadership as interim chief. Now, we sued Peter Newsham in his personal capacity for the Pershing Park mass arrest in 2002, where he gave an order for a mass arrest of people, where there was no probable cause to arrest those people, where it was a similar dragnet mass arrest. And he fought that all the way up to the DC Circuit in the District of Columbia, the U.S. Federal Court, for the Court of Appeals for the District of Columbia Circuit. And that court ruled in our client's favor. They referred to Peter Newsham's position as indefensible. They called his position ludicrous. And here we are 10 years later, and he's simply reverting back to the same illegal conduct that he engaged in at the time. And this appears in all manner to be an effort to roll back the huge gains for fundamental rights in the District of Columbia that have been obtained over the last decade.
And why now, do you think? Why are they doing this now as opposed to maybe Obama's second inauguration?
Well, it was very interesting over the last number of years when we were looking at really the results of the changes because not only were there changes in law, but there were changes in police training. So the police were all retrained in how they should handle First Amendment assemblies. And we would be out in the streets with Black Lives Matter demonstrations and other demonstrations, and people have the right to be in the streets, and they have the right to have militant protests, and the police would stand back and they'd be blocks away and they'd be facilitating traffic, and they were doing what they're supposed to do. And then all of a sudden now, with the Trump administration coming into office, it's not lost on any of us that there's a massive upsurge of opposition to the Trump administration, to a rebirth of the white supremacists and the KKK who all felt that they had to remain in the closet all these decades and now are feeling that they're welcome and that they're entitled to be out in the streets, and there are many people coming out to oppose them. And so at this moment where you have a social justice movement that's really got a fire under it and is coming out, is the very moment in the nation's capital when you have this effort to turn the clock back on basic fundamental First Amendment rights.
And we're still waiting on a verdict, which could come next week. But worst case scenario, what do you think that this prosecution could mean for the future of First Amendment activity in the district?
This has been a dangerous prosecution to begin with. I mean, in fact, no matter what happens, the prosecution itself has been a huge attack and punishment on people. It's turned people's lives upside down, and they've been drugged before this court and forced to return and return again and be here to defend themselves at trial. People that are not alleged to have undertaken any of the particular acts, but are simply being charged for being in proximity. That in itself is hugely damaging. I mean, what this says to anyone is any one of us that goes out, joins a demonstration, marches, if someone else in that crowd, someone else picks up a brick and throws it through a window, the police feel that they have the right to arrest everyone else in proximity. And that person could be a protester, that person could be a police agent provocateur. In many of our cases, we have agent provocateurs undertaking these acts and police officers. So it allows the police at any moment to extinguish a demonstration. That's the threat that we're facing here. If people can be arrested and they can be prosecuted and they can be charged and they can be drugged through the system, even if they're exonerated, that's been a huge, huge violation of just their fundamental rights. And if in fact people are convicted, that's an even bigger threat. It says everything to people in the United States that you can be charged, arrested, and convicted when you didn't do anything. You didn't do any of the underlying acts. You were just there. And
we've seen in court today a protester with a National Lawyers Guild form on her. That form was used to argue in favor of conspiracy by the government. What's your view on that? I mean, you have a form here that has people's full names and their phone numbers. Yet the government is trying to criminalize that and basic medic preparations. I mean, what's your view on that? On how they're kind of preventing basic First Amendment activity, and not only that, but like criminalizing people who seek to further First Amendment activity?
Well, it's really an Alice in Wonderland-like approach. I mean, if you think about it, we all know that the police engage in mass false arrests and repression of demonstrators. And people who come out and want to express their First Amendment rights should be able to do so without fear. But yet, people often know they may be subject to mass false arrest. And because the National Lawyers Guild and many civil rights organizations prepare in advance and think about what could happen to people who are lawfully engaged in free speech activities. I mean, in the District of Columbia alone, we represented more than 1,000 people who were falsely arrested. So it's completely sensible for people to be prepared and to be thinking about what could happen to them. And here you have the police who, in advance of the demonstration, were getting hundreds of thousands of dollars of paramilitary weaponry to use against people engaged in demonstration activity. And yet when the demonstrators themselves come out simply with protective gear to protect themselves from a police attack, that somehow gets turned against the demonstrators to indicate that they were planning something unlawful, as opposed to simply trying to protect themselves. And similarly, anyone that's consulting with a lawyer in advance of a demonstration, we talk to people all the time who want to know how to engage in free speech rights in the District of Columbia. Because they consult with a lawyer, does that mean that they were somehow planning on doing something illegal? They want to protect themselves from police repression. And when the government is using the fact that people are trying to protect themselves from police repression as evidence of guilt, it's extremely dangerous.